I'm basically here to enjoy this symposium and say welcome to everyone. My name is Connie Mayer. I'm the Associate Dean for Academic Affairs here at Albany Law School, and it is my pleasure to welcome you to Albany Law School and this symposium. I'd first like to extend my thanks to the members of the Albany Law Review. I know they've worked really hard to create and develop this very timely symposium, and so a special thanks to Meghna, who is our leader in all of this, who is the executive editor for the symposium, and she's done a magnificent job organizing this event. The symposium, promises to be thought-provoking and informative. We've obviously been through a lot in the last year or 2 years, including the pandemic and events that have challenged our democracy, including the assault on the peaceful transfer of power, new laws that seem to be limiting voting rights, new laws that seem to be aimed at stifling our First Amendment right to peaceful protest, and of course, the continuing fight against racial injustice. And so through this symposium, the members of the Albany Law Review want to engage us all in a scholarly discussion about these issues. The symposium will examine how the Constitution has endured these types of challenges, how it compares to constitutions of other nations, and whether there's a need for reform to ensure the continuation of a strong democracy here in the United States. And so to do all of that, we have with us today a panel of very distinguished guests who will be discussing these issues. And so our thanks to the Honorable Rowan D. Wilson, Associate Judge of the New York Court of Appeals, who will serve as our moderator, and our panelists, who are Professor Ava Ayers, one of our own, Professor Tom Ginsberg, Professor Jessica Naus, who's also one of our own, and Evan Wolfson, the founder of Freedom to Marry. We welcome you all. We thank you for taking the time to be with us today to share your knowledge and your expertise. And so at this time, I'm going to turn this virtual podium over to Francesca Boyer, the editor-in-chief of the Law Review. But again, welcome to Albany Law School. Enjoy the symposium. I'm really looking forward to hearing from the panel on these very, very important issues. Thank you.
Thank you, Dean Mayer. Hello, everyone. I'm Francesca. I am the editor-in-chief of Albany Law Review this year. Some of you already know this because I like to say it a lot, but for those of you who I haven't gotten to yet, Albany Law Review is known to be the first student-edited legal periodical in the United States, which is so cool. We are currently publishing volume 84, and over the course of these past 84 volumes, Albany Law Review has published critical and analytical articles written by judges and lawyers, law school professors, and all types of legal scholars on all types of legal topics, as well as some notes and comments written by Albany Law Review members and other law school students. Historically, law review articles published in legal periodicals have been extremely influential in the development of the law. And so as the editors of these articles, we really have the power and opportunity to affect change in law by publishing articles we believe will challenge and advance and improve upon the law. This year, our country went through so much, from a global pandemic to tumultuous elections to recurring instances of racial injustice. So 2020 alone raised what we're calling the great questions surrounding the US Constitution. These questions have left many of us angry and frustrated and wondering, where do we go from here? So we decided that our symposium would be the perfect place to start talking about solutions. And I want to give a special thank you to Professor Bonventry, our wonderful Albany Law Review faculty advisor, and all of the members of Albany Law Review this year. Our journal was able to run smoothly in the midst of all the chaos because of all of your hard work. To all our guests, thank you so much for being here. And to our amazing panelists and moderators, thank you in advance for sharing your wisdom and having this important conversation with us. And with that, I'm going to turn things over to Meghna, who is our executive editor for Symposium and the mastermind behind this event. I can take zero credit. So thank you, everyone, and I hope you enjoy.
Thank you, Francesca. So before we get started, as a general rule of thumb, you may utilize the chat function throughout the event to discuss topics that our moderator and panelists will be speaking about. As a note, they will not be monitoring the chat, but my co-host and I will be. If any questions come up, we will make a note of them. We only ask that you interact in a professional manner and be respectful of our speakers and those with differing ideas. And on that note, let me introduce our remarkable moderator and panelists. So our moderator for the evening will be Associate Judge Rowan Wilson of the New York State Court of Appeals. Judge Wilson graduated from Harvard Law School in 1984 and was admitted to practice in California and New York. From 1984 to 1986, he served as a judicial law clerk to the Honorable James Browning, Chief Judge of the United States Court of Appeals for the Ninth Circuit. In 1986, he joined the firm of Cravath, Swaine and Moore in New York City as an associate and became a partner there in 1991. On January 15, 2017, Governor Andrew Cuomo nominated Judge Wilson to serve as an associate judge of the Court of Appeals, and the New York State Senate confirmed his nomination on February 6th of that year. He is one of the boldest and most independent voices on behalf of fundamental fairness to sit on New York's highest court. And when he dissents, which is not uncommon, he's always arguing for greater justice. And next, I would like to introduce our first panelist, Albany Law School's Assistant Professor and Director of Governmental Law Center, Ava Ayers. Professor Ayers graduated first in her class from Georgetown Law. She then clerked for the Honorable Sonia Sotomayor on the U.S. Court of Appeals for the Second Circuit and for the Honorable Gerard Lynch on the U.S. District Court for the Southern District of New York. Prior to teaching, Professor Ayers worked for 9 years in the office of the New York Attorney General, where she was a senior assistant solicitor general. During her time, she worked on various high-profile cases involving immigration law, states' rights, constitutional rights, environmental law, and other issues. Recently, Professor Ayers has authored articles on immigration law, federalism, legal ethics, and other subjects, as well as authored a book, A Student's Guide to Law School. Our second panelist is the University of Chicago's Leo Pitts Professor of International Law, Ludwig and Hilde Wolf Research Scholar, and Professor of Political Science, Tom Ginsberg. Dr. Ginsberg graduated with a BA, JD, and PhD from the University of California at Berkeley. Before teaching, he served as a legal advisor at the Iran U.S. Claims Tribunal at The Hague. Currently, in addition to teaching and authoring scholarly articles and books, Dr. Ginsberg co-directs the Comparative Constitutions Project, which focuses on gathering and analyzing the constitutions of all independent nation states since 1789. He continues to work with numerous international development agencies and foreign governments on legal and constitutional reform. Our third panelist today is the University of Toledo College of Law's Professor Jessica Naus. Professor Naus received her JD from Albany Law School and LLM from Yale Law School. During her time at Albany Law, she was a production editor for the Albany Law Review and valedictorian of her graduating class. Since graduating, Professor Naus has worked as an appellate court attorney for the New York State Supreme Court Appellate Division, 3rd Judicial Department, and as a law clerk for Justice Howard H. Dana, Jr. of the Maine Supreme Judicial Court. In 2019, she delivered the Catherine D. Katz Lecture at Albany Law School, and in 2020 received the Eastman and Smith Faculty Achievement Award. Currently, she teaches courses in constitutional law, family law, reproductive technology and law, and sexuality in law, in addition to authoring scholarly work in the intersection between constitutional law and family law. Our last panelist is Evan Wolfson, the founder of Freedom to Marry. Mr. Wolfson graduated from Harvard Law School. During the 1990s, he served as co-counsel in the historic Hawaiian marriage case that launched the ongoing global movement for the freedom to marry, and has participated in numerous gay rights and HIV/AIDS cases. Citing his national leadership on marriage and his appearance before the U.S. Supreme Court in Boy Scouts of America versus James Dale, the National Law Journal in 2000 named Mr. Wolfson one of the 100 most influential lawyers in America. In addition, Time Magazine has named him one of the 100 most influential people in the world. In 2012, Mr. Wolfson received the Barnard Medal of Distinction alongside President Barack Obama. And currently, Mr. Wolfson devotes his time to advising and assisting diverse movements and causes in the US and around the world, as well as teaching law as a distinguished visitor from practice at Georgetown Law Center and as a distinguished practitioner in grand strategy at Yale University. In addition to this work, Mr. Wolfson serves as senior counsel at Dentons. We're excited to have these fine group of speakers with us today. Now I will turn it over to Judge Wilson.
Thanks, Magna. So I think the Law Review conceived this, I think, brilliantly as not, let's look at a little bit of scholarship about some words in the Constitution. There's plenty of that. But rather, let's think about this from, whether you want to say a 50,000-foot level or sort of a whiteboard level. Let's think about how we got here, where we came from, how we got here, and are there things that we should be thinking about more broadly than just what do particular words in the Due Process Clause mean? And so to kick us off, and anybody on the panel who'd like to can start with this one. The country was formed, as you all know, by a fairly violent revolution. A lot of blood was spilled, and the words that started it had to do with life, liberty, and the pursuit of happiness as inalienable rights. But when we get to 1789, we get to the Constitution, you don't really find the Constitution itself saying much of anything about individual rights or inalienable rights. And even when you get to the Bill of Rights, many of those are framed in terms of what the federal government can't do rather than what the inalienable rights of people are. So how much of what we've are now living with 230 years later, depending on where you're counting from, is because of a disconnect between those documents, between either the words or the principles behind them? How much tension is there between them, or have we moved? Has one vision of what the nation is supposed to be proved truer than the other? I don't know who'd like to tackle that.
Maybe I'll jump in to avoid an awkward silence. The way I think about this is, of course, the purposes of those two documents were really very different, right? A Declaration of Independence is basically a statement on the international claim, and as you note, sounded in liberty and a celebration of we the people. And of course, that phrase comes back 13 years later. But a constitution, always and everywhere, has an element of political compromise. And as we know, some of the compromises that were made in 1787 are fairly odious and continue to haunt us today. So I guess the way I think about it is we have these founding ideals, which are always with us, and that's part of our inheritance. And we have to somehow channel them through a political system, which is hardly ideal, and one in which, is sort of, it's just a continuous struggle to try to achieve those ideals, two sides of the same coin.
But of course, we the people in both of those was not maybe the group of people we think of as the people right now. And how do we reckon for that? I mean, to put it differently, the white male population of the United States at the time was maybe 800,000 tops. I mean, the smallest state in the Union maybe has that many people, or a little bit less than that now. We're dealing with a constitution that was created by, not just people who aren't alive any longer, but a quite different set of people than are represented in the country at the moment. And how do we recognize that? How should we account for that, if at all, in either constitutional interpretation, or, do we need to rethink things?
Well, Justice Ginsburg, famously wrote that the story of our Constitution, and by that she meant not just literally the document, but the system, is expanding the circle of those people who are included, and acknowledging where we have gaps or omissions or failures, and widening those circles. And Justice Marshall has expressed similar sentiments. And I think we can have a kind of a narrower version of that discussion, which is what you just put on the table, Judge Wilson, this question of who's represented and whom have we left out and so on. But I also think there's a larger point that's relevant to this whole discussion, which is what do we mean when we talk about the Constitution? One way to think about our system and the Constitution is, the literal document that, as Professor Ginsburg said, is set up to order the structures of government and to guarantee certain rights, and those have expanded and enlarged over the years, and then they're interpreted and so on. And that it's a thing. But I also think, in my vision of the Constitution in American understanding, is that we are also part of the Constitution, we the people. And just as the people have expanded, so can we have a more expansive understanding of how to make our Constitution, our system, work, part of which involves the document, but part of which involves our involvement as individuals, and part of it involves the role and steps, but also improvements and missteps of the institutions that are articulated within the Constitution. The Supreme Court is a bunch of people, but it's also a player within a system. So is Congress, so is the president, and so are we the people. So to me, as an activist, not particularly a scholar, I think it's important to understand that the Constitution is not just the words on the paper, it's what we make of it going in the past and what we make of it going forward.
Well, do you think there are enough? I'm sorry, Professor.
Go ahead.
Naus, no, go ahead. I have a question that I can easily follow up with in a minute.
Thank you. So no, I was just going to jump in. I agree with a lot of what was just said, and was having similar thoughts as well. I mean, I don't think that the consent of a few white men in 1789 constitutes consent today. One thing I think is really important that needs to happen is that we stop talking about the people who wrote and we stop centering the people who wrote and ratified the original Constitution and giving them so much airspace in our constitutional discourse. I think that one way to begin that work of decentering is to think about the transformative potential of the amendments. And so not just be in 1789, right? And I think, and when I say amendments, I mean it very broadly in the way that was just discussed, of not just the textual amendments, but also non-textual amendments. Because I think, of course, all of us probably recognize that many of the most important recent developments in constitutional law were not the result of Article 5 amendments, but were perhaps the result of Article 3 interpretation, or political action, right? And were pushed by we the people and social movements engaging as constitutional actors ourselves and as citizens. And to me, that's, given where we are today, that's kind of what we have left to work with is we the people engaging directly. But I think that we don't, to the extent that we do have a number of textual amendments, and I'm thinking particularly of the Reconstruction Amendments and the 19th Amendment, that have not realized their transformative potential. We have work to do in terms of just getting to, I think, the consent that was. So when we talk about consent, or the legitimacy of the document, I think we can think about the consent that was given in those later years, right, in 1865 or 1868 or 1920, right, and that was a very different consent. And then today, I think, to the extent that, like, whatever level of legitimacy we think the Constitution has comes in part from the ability of marginalized social groups to believe that they can engage as constitutional actors, right? That's their engagement in the process is part of what gives maybe I said we shouldn't talk about the framers, but Madison used the frame tacit assent, right? The tacit assent to the legitimacy and power of the document. So I think that, working from that idea of people as actors is kind of our next place that we need to think towards. So I'll stop there.
Judge, could I add something to that?
Please.
So I love everything that my co-panelists have said so far. And I think just to pick up on the point about what we mean when we talk about the Constitution and what it means for it to have legitimacy, for me, there's three things that the word could refer to. One is the document itself, 7,600 words or whatever it is. One is the huge body of precedent and case law that actually tells us what that document allegedly means. And the third is discourse that we all participate in, a conversation in which the word constitution is used, which is different from the body of case law in the sense that saying the word constitution or constitutional or unconstitutional changes the conversation that we're in. When you say to someone, you violated my constitutional rights, that's now a different conversation than if you had just said, you're violating my legal rights. People talk in this country with particular reverence about the Constitution in a way that other legal texts don't get, that goes way beyond what courts say. You hear mention of the Constitution during political conventions, and very, very few legal texts get that sort of stature. And that discourse, to me, has a lot of different components, only some of which are legal or even refer to the law. Some of it is principles, right? When we say, we live up to the ideals of our Constitution, I mean, sure, you can find ideals in the Constitution if you look hard, but that's the point. You sort of have to look hard. It's not just a covenant. It's not just a deal or a bargain. It's something that articulates principles that we all interpret differently. But it's also a statement of national identity, and that concept of we the people is more than just sort of the expectations for justice that we all want to hold ourselves to, about which there's obviously very little agreement or consensus in the country. It's also a statement about who we are, and that broadening circle of inclusion that Professor Naus was talking about, I think, reflects the way that we put a lot of weight on whatever this Constitution thing is that we talk about when we talk about the Constitution. We look to it to define us. And so fights about inclusion, about who counts as fully a person or who counts as a full member of our political community, those fights get put into constitutional discourse in a way that's kind of an awkward fit, given that the document in some ways, as I think Professor Ginsburg was saying, is just supposed to limit the powers of the federal government. If you look at the legal effect, you could argue it does a lot more than that, but you could argue it does no more than that. And so we get these mixed conversations where so-called textualists or originalists are arguing, look, the Constitution is a pretty limited aspirational document. It doesn't define the scope of our goals for ourselves as a collective people. And others who say, I'm trans, I'm a person of color, I want to be included too, and I demand that the Constitution accept me into its sphere. I'm not sure the Constitution can bear all the weight we put on it.
Well, that's what I was going to ask you actually, is the fact that most Americans put so much weight on the Constitution, does that also give people the general idea that it's sort of immutable? That is, or to put it differently, when you said that we look to the Constitution to define us, we should be looking at us to define the Constitution, maybe. But when we think of it as, look, this is the Constitution, and it's been here, and we've been with it, it's hardly been, I mean, you could make an argument that really, other than the Reconstruction Amendments, the amendment giving women the right to vote, and the Bill of Rights, the other amendments really, yeah, they're fine, but we could have lived without them. And that this is kind of the original document we've had for a long time, and it stands for something, and whatever that something is doesn't really change. When we put weight on the document or weight on the Constitution in regular public discourse, you violated my constitutional rights. It's something that's super important and that maybe is harder to change than just a statute or a custom. Reactions?
I think if we expected the Constitution to be, somebody had the phrase, a machine that would go of itself, and you just put a quarter in and get justice or the right answer out, that is putting too much weight on the thing and expecting too much of it. I think what the Constitution was intended to do was to create safeguards and structures and mechanisms by which, again, we the people, the larger constitution of the us, can achieve the more perfect union, the right result. And
so how do we activate people to do that? I mean, unless you think that people are already sufficiently activated and think of themselves as having a role in constitutional discourse. I mean, presumably the people on this, this symposium, the audience thinks that or will think that by the end of this, but that's a pretty small group of people.
Well, if you look at the activism we've seen, so empoweringly and excitingly over the last year, very dramatically around racial justice and more. If you look at the Me Too movement that is overlap with that, if you look at the LGBT struggle, but beyond that, if you look at the intense conversation around democracy and the need to defend our democracy because of the threat to it from within as well as without, that we've all become so conscious of I think more and more people have been called to action. Now the question is, can we turn that call to action into the action that will be necessary, both in terms of reforming the constitutional structures, but also in terms of keeping the polity invigorated? And I do think at different periods in American history, we've been able to summon ourselves to that call. And at other times, of course, we've fallen short.
Much more frequently, though, that has been, to the extent that that's affected the Constitution, it's affected it through the courts rather than through amendment, right? We still have the same organic document largely, but and there are plenty of examples through history of interpretations changing. Do you think that the current, take the various things that have been in the forefront in the last year, have been sufficiently focused on or directed enough to cause that kind of constitutional change, or are these being thought of as sort of either social or political, not constitutional, legislative perhaps?
I have my view, but I don't know if anybody else wants to go first.
Apparently nobody does, so let's have your view.
Okay, well my view is, as somebody who spent most of his work and is not a scholar in trying to achieve change, whether at the constitutional level or equally importantly in the social and political level, I always was more focused on the rights parts of the Constitution and sort of took the structure parts for granted. And now I've come to see that the structural parts of the Constitution, in other words, the parts that organize the structure of government and the balance between majoritarianism and minoritarianism and systems, and we can talk more about those, are the ones where we have to turn real attention to some dramatic reform in the way that we have not always had to do. And I tend to think, and I still think, that the rights elements of our constitution system are still adequate to the task if we do our work. In other words, we didn't need a new amendment in order to assure gay people the transition from oppression to inclusion, for trans people, for women, and so on. I mean, an equal rights amendment is the right thing and would help, but we are able to achieve, I think, what's needed without those constitutional amendments through our system, whether it's the courts or political engagement or cultural shift and so on. But the big problem I think we face right now, and here I'll stop, is the structures of our government regarding making sure Congress works, making sure that Congress is not disproportionately unrepresentative of the American people beyond, in a way that's way out of whack. The balance amongst the different institutions, the functions and so on. Those are the things that actually need real reform. And those are the things I tended to pay very little attention to through most of the time. So in other words, I don't think we need a new amendment in order to make sure people's rights and inclusion are achieved. I think we need to do that through the political engagement in our constitutional system. But the constitutional system that orders political power in our country, I think, needs some reform.
That goes back a little bit to Professor Naus's point, maybe indirectly, but it isn't maybe so much a question of delegitimizing the people who started the country based on who they were, but recognizing that the country that they were dealing with was not at all the country that we're dealing with now. I mean, nothing like it. Or to put it differently, if you could somehow bring them here, they might arrive at a quite different solution than the one that was appropriate 240 years ago. Professor Ginsburg, any thoughts about structural changes?
Absolutely. I've been thinking a lot about it. Now, my angle is partly comparative, which is I study the constitutions of every other country, and we are really an outlier on so many issues. Some of those are rights issues. So, for example, there's no general right to vote in the American Constitution. Right. 14th Amendment, but it's not complete. And the 15th Amendment and such, and the 15th Amendment, but it's not complete. And we end up throwing way too many questions to the courts. Our structure of government is really out of whack. I mean, obviously, if we were no one has ever really borrowed the Electoral College. It's not a good invention. It's much more like, at best you describe it as the horse and buggy, a 200-year-old technology, but I think, it's even worse than that. And so our political system is an outlier, and it's really hard to fix formally. And that's why I think the points Evan was making about how the cultural side, we've got to do this through mobilization and things like this, but it really is an uphill struggle because the structures are sort of rigged against change. I want to make one other observation, though, which is a comparative one, which is we do have something unique, or fairly unique, and it is that sense of veneration. It's worth noting that even these insurrectionists and white supremacists who were trying to overthrow the government spoke in the name of the Constitution. Like, they actually thought they were defending the Constitution. Now, ultimately, they were wrong, and we all can agree they were wrong, more or less, except for 121 members of the House of Representatives, apparently, and 6 senators. But, that provides at least a resource for us to say, your position really is wrong. You really did lose through the political channels, and we've got to move on. So, not many countries have that veneration. And that means in a country as diverse and complicated as ours, without that veneration, there's not very much that holds us together at all.
I mean, you think there's an argument that it's really that continuous sort of veneration rather than the Constitution itself or the structures of the government that have allowed it to persist, fairly well for all this time?
I would agree with that. I actually wrote a book on, it's called The Endurance of National Constitutions, What Makes Constitutions Last a Long Time. And it turns out, looking at all constitutions since 1789, most of them don't last very long. The average age in death is about 19 years old, 19 years. That's obviously way too short. And when we look at the things which predict a long lifespan in constitutions, sort of some intuitive things, a certain amount of flexibility, easy to amend, a certain amount of inclusion at the outset of drafting the Constitution, actually a lot of detail, which I can talk about separately if anyone was interested. But these are all things that our Constitution lacks. It has managed to last a long time, despite the fact that it was drafted by, as you noted, a small group of people, that it's really hard to change. And it really lacks detail in many features. And somehow that has created this process, as you referred to, the veneration and a kind of process of national conversation. It's not always pretty, but it does, on average, move us forward.
Yeah, if I can just jump in for a minute on some of those points. I to start out, but just kind of underscoring the lack, I think the lack of detail has in a lot of ways caused a lot of the things that the shifts that we've recently seen, and the ability of people to, everyone can invoke the Constitution, right? And it's maybe it's a smokescreen, and maybe everyone understands that it is, and so maybe that it's neither here nor there. But I think so at our school where I teach, we divide, as I think many schools do, but we have one semester on structure and one semester on rights, and so that's kind of the big division. And for many years, the structure class was never, we had theoretical conversations about, what, the constraints on executive power, the impeachment process, of the pardon power. And they were never, all of a sudden, all of those structural debates were animated and came to life in a way, in an odd way, because we were like on Zoom instead of in person, and everything was kind of crashing down around us as we were like having these conversations. And by the end of the semester, no one even remembered impeachment because it felt like 5 years before, right? That's the magnitude of change that we've had, though. And I think, back to the point that someone made about ceding too much to the courts, I think that's what we've seen about executive power, is that if there's no one standing there to do anything, and you get cases where the courts just seem to cede the power, right? And Trump versus Hawaii, in cases where the court just says like, okay, we defer. And so there's nothing left, because there's not detail, and our Constitution isn't one that enumerates with a high level of specificity. It's just, marking the outlines, right? And so I don't know. I mean, I haven't, fully processed this shift, but can just say that in teaching and seeing the way that the conversations went, it's a foundational change to the way that students and the people that are thinking about this, as people just coming to it, experience the structural pieces of it. So
I worry, and maybe nobody else does, that the over-reliance on the courts for the resolution of sort of important social and political issues is a little like what Plato described, that you'd have some very small enlightened group of guardians who manage the polity, which is not, I think, the way that the country thinks of itself or wants to think of itself. But is that a worry anyone else shares?
Well, if I could say, I mean, I think it depends on who those enlightened guardians are. And if they were better than the alternative, then I guess they're better. I don't know that elitism is a bad thing per se. I think it just usually works out poorly. And part of the reason it does is that you need popular trust and buy-in, and you won't get it. And particularly now, thinking about the prospects for constitutional change, for reform, just to pick up things a couple of other folks said, when we saw the attempted insurrection on January 6th, I think it was a profound illustration of, what my colleagues have been saying. People thought they were storming Congress in the name of the Constitution to stop the Electoral College from voting. I very much doubt the founders would have imagined that a popular insurrection could be caused by what I think was, at least in part and maybe largely, a scam. In other words, a fundraising scheme by political candidates who knew they had lost to raise money. There are any number of examples of things the founders couldn't have imagined or couldn't have dealt with. And in those situations, I'm not unhappy about the courts being there to resolve them, because I think they're probably preferable to many other mechanisms. So Judge, this is to respond to your question about, is it unfortunate that we have the courts there? Well, the courts as an institution, I think, did quite well with challenges to the election. I think that people channeled their grievances. And in fact, you saw many of the people who were engaged in sort of trying to propagate the fraud that the election had been stolen, admitting when they actually found themselves in a courtroom that they hadn't meant it and that they didn't think anybody was going to take them seriously and so forth. That didn't translate into the movement dissolving and everybody going home, but it's not nothing to say we found a forum where some sort of norms of accountability, if not honesty, prevail. But the overarching point, I think, is that you can't expect the Constitution to get too far ahead of the society itself. That if we as a society are plagued by racism, plagued by inequality, plagued by violence and ignorance, the Constitution is not going to change all that. It may sort of help around the margins, but as a tool, it can't help with those things, because as we were saying before, it's partly composed of the people. It is partly made of the people. So let me just say it, and then I'll stop, because I just love this study. There's a book that's well known among legal academics called Order Without Law by Robert Ellickson, which recounts his experience of going to California cattle country and studying the people there and their understanding of the rules that governed whose fault is it if a cow goes out in front of traffic, or if somebody's cattle wander out beyond their fence. And what they found is there's a lot of law, and first-year law students study some of these principles, and the ranchers had no knowledge of that law at all. They thought they did, to the point that when they got into court and a judge told them what the law actually was, they laughed at this ignorant judge who has no idea what the rules are. Because there's a difference between the law that the courts think of and the law that the people have. We clearly have that with the Constitution too. And it's not just the sort of Trumpist insurrectionists who stormed the Capitol who think they know the Constitution. I do too. I think I know the Constitution, and it's not necessarily what the courts say. I think they're wrong, because the Constitution is a set of moral concepts that live in discourse, not in text. But all of that said, I'm very, very grateful that I don't have to be in the position that Evan's in, that others are in, or actually having to solve these problems for a society, because I think these questions about when do you rely on the courts and when do you rely on popular campaigning, I know the answer is always both, that you always keep trying to push forward with both of them, but I think those strategic decisions are just agonizingly difficult, and I have no end of admiration for the people who have to grapple with them.
May I jump in here? Because, and I think Evan may have something to say, having done a lot of litigation. From my point of view, I sort of agree with the thrust of your question. The courts have way too much power, and that has led to, the politicization of the judges of judiciary, to the point where I think, no Supreme Court, no Mitch McConnell, then no Donald Trump. And that's a real distortion that, again, the founders were rolling over in their graves to think that we were fighting elections over who was going to nominate someone to the Supreme Court. I think it's incredibly distorting. And not only that, it encourages us to articulate our claims as absolutes. This is my right to this. You can't have any of it. And in many cases, of course, rights claims are really about competing interests. And, they're political in that sense. And we might do better if we took some of those things into the society, into the legislature, into places outside the courts. And I don't just say that just because the courts tend to be really conservative now. I just think that's the right way to govern a democracy, from my point of view.
I mean, for example, there's, if you think about gun violence in the United States, right, which is a huge issue. Isn't there a good argument that really is a political issue that should be decided by the legislature and not something that the Supreme Court just granted cert in the New York case involving open carry? Why should that be a constitutional issue? I mean, there may have been reasons, in the 1700s, but a gun is not a gun is not a gun, right? I mean, they didn't have guns that do what we have now.
Well, I do have some problems with the courts, particularly the court as it's composed and as Mitch McConnell has packed it now. And I assume we'll talk about the Supreme Court and structural reform there maybe later. But I also think it's important to honor the importance of having courts and a check on temporary majorities, passions, prejudices. Not everything should be put up to a vote, et cetera, et cetera. And so there's a reason we have courts, even if the courts themselves have not always lived up to the responsibility and respected the boundaries and so on. And there are times when we want the courts to act boldly, and we don't want to have to wait 50 years to persuade people to vote for something that ought to be a right or ought to be protected, et cetera. So it's not an all or nothing answer. So I actually think while there are instances in which the courts are out of whack, and there are things we should do to fix that in our current moment, I actually don't think that in general the problem is the courts are too strong and that we have put too much in the courts, except in the sense that it reflects the fact that some of the political branches have become too weak or too uncommitted to the democratic values and even the vision that Professor Ginsburg just talked about respecting and trying to find a balance amongst interests. So you have Congress having largely abdicated any meaningful role in government through dysfunction that needs to be addressed structurally now, as well as through the political engagement of the people. And you have a presidency that we sometimes think of as too weak when we don't think the president is doing enough. And then other times we think it's too strong. And it seems like, a Trump can come in and do all kinds of damage, even with the courts often ruling to check some of those abuses. So I think the problem is not so much that the courts themselves are where we have put too much power, and that's the problem. I think it's more the other parts of the political and constitutional order are, as we've said several times, out of whack and need to be attended to, whether in some cases through structural reform or always through engagement in the process. And I guess the last thing I'll say, and then we can put this in its proper place later, is, as I've already alluded to, yes, I was part of a campaign, for example, to secure the freedom to marry for same-sex couples. And the strategy was ultimately to win in the Supreme Court. But in order to win in the Supreme Court, we had to engage in every other arena of this country and of the system at the state level and at the national, at the federal level. We had to engage in national discourse and in local and personal attitudinal change. We had to win in legislatures. We had to win in state courts. Some of the state courts got it wrong. Looking at you, Judge Wilson, but before your time. And ultimately, nevertheless, we rebounded from our loss in the Court of Appeals in New York and engaged the legislature and the governor in New York and won through that. So there are many parts to this machine, and mostly I think that is a good thing, even if it doesn't immediately deliver the result we want. And if we simply think all we need to do is do one fix that will just achieve whatever particular agenda point we have right at the moment, we are missing that important complexity that is part of what has preserved freedom, although it has also retarded freedom and equality and the vision we want, which is the challenge we have within political engagement, not just the structures of the Constitution, though there are structural changes that need to be made as well, including addressing the courts.
If I could just really quickly jump in very briefly, and then I know we want to move on. I agree with a lot of what was just said, and I was having those same thoughts about kind of the way that the same-sex marriage movement progressed, right? And you need to build all of those other aspects first before you have that win in the court. But I worry a lot about the courts, and I'm worried about the courts, so I'm not, but I think I want to just, this is maybe, and I mean, this is a very obvious point, but I think it bears observing that the thing about the judiciary is that it is the only branch that is, or at least has a practice of, always justifying and reasoning its decisions. And so we can engage with courts in a different way, I think, than we can with, the political branches for, the legislature and executive for that reason, because we get reasoned opinions and we get conversations and we get, that this context, and the courts have this ability to speak, and they don't always do it clearly or with one voice or in what, but it's something that's unique about the courts that I think is worth thinking about as we think about, where do we want to engage, because it's such a different process and a different, the result is so different. Right. I mean, it's not the case that in law school, we only look at the actual result or the yes or no. Right. I mean, and some people would say like, that's all that really matters at the end of the day. And I know that articles have been written, but, we comb through all of the pieces and the reasoning and the opinion and try to use those things to build other things. And that's unique to the judiciary, I really think. So.
Well, we do get reasoned opinions from administrative agencies, but to be fair, the reason we get those is because there's judicial review of them. If there weren't, then you probably wouldn't.
And arguably, that's a constitutional requirement that comes from the right to due process, that the arbitrary and capricious standard is codified, but it might be there anyway, if not. Sorry, Jessica, I didn't mean to cut you off. You looked like you wanted to say something. So, Judge, if I could just add to that, then I think that it's absolutely true that sometimes courts have too much power, and I don't know how to measure that, whether it all balances out. I mean, I think on the gun issue, I would say that, and I think Professor Ginsburg knows this better than me, but of all the societies that have dedicated their best minds over centuries and millennia to figuring out what is morally essential as a matter of justice, none of them have come up with guns as something that is morally necessary, except for the Second Amendment. And I think there's a theory of justice that's very tenuous behind the idea that guns should be a right or a moral necessity, which means, in my view, yes, it's a mistake to constitutionalize gun discourse, maybe even a mistake to give it to the courts altogether, although of course they have to get involved somehow. But on balance, yeah, I have no idea whether it's good or bad. But what I do think is very clear, picking up on what others have said, Congress is too weak in the sense that Congress no longer, not all, but most Congress people no longer think that constitutionality is part of their responsibility in the same way that it is part of the Supreme Court's responsibility. we're seeing this in the current arguments over DC statehood, where, arguments, particularly from the Republican side, where Democratic arguments speak the language of justice, Republican arguments speak the naked language of power. Well, it would give Democrats more of an advantage. And that's sort of why we're not going to do it. And implicit in that is the assumption that that's an appropriate form of discourse for a congressperson to engage in, to say, we're sort of more concerned about the politics, the power dynamics. And as somebody who's defended a lot of statutes that the New York State legislature passed, I can say from personal experience that there's lots of cases where the legislature decided to pass a law and let the courts figure out whether it was constitutional, that's now sort of an accepted understanding of the role of the lawmaker. Partly, I think that's because a lot of lawmakers are not trained in law. And I think it's weird when people say we need fewer lawyers in the legislature. But I also think that it's because the idea of the legislator's role has changed. And I do blame that on the Constitution, in the sense that the more we make the Constitution the business of the courts, the more we encourage others to defer to them in that role. The one last thing I'll say is, I don't know whether the courts have too much power as such, but the justices of the Supreme Court have too much power. The individual people, I think, absolutely. If you visit the Supreme Court and get to hang around a justice's chambers, it feels like you're in the presence of a monarch, and it's weird. Right? There are like the skittering servants who bring gum to refill the tray of whatever it is. It's not something that feels super comfortable in a democratic system. I'm all into mahogany wood panels and great mansions to democracy with magnificent columns out front. That's great. But the lifetime tenure combined with the sort of all out, go to auxiliary lighting and submerge the submarine, we're going to battle now when there's a Supreme Court vacancy. That's not a healthy amount of power to give to a single individual. And I know we're going to talk about court reform later, but I think that whether or not the court has too much power, Congress clearly has too little, and the justices have themselves personally have way too much.
Why don't we talk about that now for a second? I think I have to turn my screen this way. You probably can't see it. There's a tiny little cup of espresso in the corner there. Judge Fahey and I walked down to Dunkin' Donuts just before this so that we'd be properly caffeinated.
As the framers intended, Judge.
Yes. So my term of years is 14, and that's the end of it. And, the reason, the justification for life tenure for federal judges is so that they're not subjected to a bunch of outside influences and they'll make decisions as the law requires. But I, as Meghna started out in my introduction, I dissent an awful lot. I say what's on my mind. I don't feel as if there's anything anybody can do to me short of shooting me to stop me. And life tenure isn't going to change that. So what about, would we help both Congress and the courts by having a term of years? It doesn't have to be 14. It could be 19. It could be 21. It could be something. And then keeping in mind that the average life expectancy for a white man in 1789 was 38. So when the framers were talking about, and I don't want to put too much on them, but when they were thinking about life tenure, they were not thinking about appointing a 39-year-old to the Supreme Court who might live 50 years. What about that?
Maybe I'll jump in again. Comparatively, we are all alone. There are other countries which have nominally life tenure, but all of them have mandatory retirement ages, and the terms in those countries on the Supreme Court tend to be rather short. And I agree with you, Judge Wilson. I think it's utterly distorting of the rest of the political system, precisely because now the incentives are to, especially now that the filibuster is gone and we're fighting elections over these things, the incentive is to find for the Supreme Court the youngest possible, most loyal partisan you can, knowing that they will be there for decades. So we've got to do something about this. And there's a lot of good arguments, different proposals. The reason I think it's distorting, though, to just echo back to the previous conversation, I don't think it was right that Anthony Kennedy gave us marriage equality. And I know, Evan, you did all this work with all these other institutions and things were bubbling up. But the idea that one individual, is going to decide who was president, he gave us George Bush, marriage equality, Citizens United, juvenile death penalty, that's way too much power. And it has increased the stakes of appointments to the point where the whole political system has become distorted. We need to find ways to reduce the stakes of the individual appointments significantly, or we're just going to continue to have this distorted situation. in our constitutional democracy, from my point of view.
So what, does anybody have any ideas about what could be done to, I mean, I take it nobody thinks that the federal executive is too powerful. I'm sorry, is too weak. If anybody does, they can certainly speak up. But I think we're focused really on the wondering why Congress is not as effective perhaps as the balance would require, and what's to be done about that?
Before we go to Congress, could I just throw in a couple thoughts about the court?
Of course.
So full disclosure, I'm on the advisory board of a campaign called Take Back the Court, which is the organization that really has put the idea of expanding the Supreme Court into the discourse. And when it started, virtually no one supported that. And the first thing that anybody would bring up is, quote, court packing and FDR, et cetera, et cetera, et cetera. And now, of course, there's significant discussion and momentum, though not yet critical mass for that idea. But the idea of expanding the court is at least on the table as far as discussion. And I actually, as you might infer, support that. I actually think that is a remedy that could be taken now that would restore the court's legitimacy, that would address the court packing that Mitch McConnell and the Republicans have engaged in over the last 3 seats at least. It would address some of the ways in which the court is really completely out of whack with the politics and majority of the country. Now, I actually believe in a minoritarian check. I think I disagree with Professor Ginsburg on the idea that there should be a role for some of that ability to say, we're not going to wait 50 years and expect minorities to clamber their way over every obstacle and persuade everyone before we end a violation of their rights and their exclusion. But I do agree with Professor Ginsburg that the current way we've ordered that has put way too much power and way too high a stakes on each individual appointment. And I think we can address that through structural reforms. And the reason that expanding the court is one that I would put on the table here, although I think the idea of term limits, as you mentioned, Judge Wilson, or some kind of rotation and so on, there are other ways that, there are other things that could also be done that might make for a healthier integration of the judicial function so that it doesn't lose its minoritarian check and balance function, but is not completely out of whack and completely idiosyncratic and overly empowered. The reason I like expanding the court amongst that list of things, however, is that's one that our Constitution absolutely allows. We don't need to amend the Constitution to change the number of justices. They've been changed at least 7 times over the course of our country, the number. And Mitch McConnell changed the number just in the last few years, when he brought it down to 8 under President Obama, and then kicked it up to 9, including in the week before an election, contrary to what he had said previously. So that's something we can do. That is a structural reform, unlike the Electoral College, unlike the Senate, but similar to some of the other things we need to do around gerrymandering and money in politics and so on. That one is one that we can do. And I think it would lead to a healthier balance and integration of the court into the system, but still able to play the function that I respect.
I mean, don't you think, or do you think, or do you worry at all that that will simply politicize the size of the court? That is, the balance will change in Congress and the court will go up or down in number. That the same game that's being played with who the judges are now will be played with the size of the court.
Well, one answer to that question is, when someone robs you and you're trying to go get your wallet back, you don't worry that if you take your wallet back, they're going to take it again. This has already happened. The court has already been packed. The courts have been packed. There have been delegitimizing abuses in the last several years, at least, as I said, with regard to the last 3 seats on the Supreme Court, and the hundreds of court judges that McConnell blocked Obama from filling and allowed, or not allowed, and that was the only thing basically they did other than cut taxes and abuse rights. So curing that, not just taking that for an answer, is not politicizing. That, if anything, is our best hope at depoliticizing. Bringing the court to a number like 13, is it possible that somebody else would then turn around and say 17 and so on? It's possible, but it would be a struggle and a battle. And I think there are ways in which the American people could address that and resist that. And Professor Ginsburg is certainly more of an expert than I, but we have Supreme Courts in other countries, as we do in other states, as we do in the federal judiciary below the Supreme Court that are of much larger numbers than 9. And those function. So I think we need to cure the problem we have with a legitimate, constitutionally appropriate means, and then, continue to engage the political system, as I've said.
I'm just going to throw out one idea really quickly, which is I do disagree on that. I don't think expanding the court is a good idea because of the reasons Judge Wilson said. If you think about it, it increases the stakes of the court, not decreases. It makes the fight over appointments more salient as an electoral issue. And if you think about it right now, where we are with the 6-3 Republican majority on the Supreme Court, Mitch McConnell did pack the courts. I agree with you, but now he's spent all his ammunition. He can't go back and say, "Oh, we got to elect some lunatic because of the Supreme Court anymore." To get Roe overturned, they've got the majority, and they're not going to overturn Roe either. And so, in a way, the better politics, I think, are to move on. Many of the other ideas are excellent. Yet, have all federal appellate judges come in and rotate on the Supreme Court or something like that, or an 18-year term. There's lots of good ideas out there that don't involve actually.
If I can just quickly jump in, I think in part, I don't think that this is a disagreement with anything I've heard that, I think it's absolutely uncontroversial that our current system is crazy, right? I think the way that we deal with the Supreme Court is not, it doesn't make a lot of sense. I think it's controversial which of these, alternative options is the way to go, how we should reform it. But I think the idea that it needs reform. And I think for that reason, I kind of come down on, if you're assessing like how much do you have to lose, what will you lose if you depart from the status quo, the current thing? I don't in this moment feel like there's a whole lot to lose because it's so out of whack the way that we do things, so I think you can enumerate, and you've already heard a lot of the possible alternatives. At this point, I think it's time to be talking about moving on from should we change to which of these possibilities is the right one.
I agree with that point, but I also disagree with it. I think that we're in the worst of all possible worlds in the sense that we're now locked into a death spiral, and I don't see a way out of it. I don't think we've hit the bottom of that death spiral yet. I don't think we have a QAnon believer on the Supreme Court. I don't think we have a sort of Trumpist judge on the Supreme Court, although there are plenty of Trump appointments. And what I mean by that is I think that we still have a federal judiciary, particularly at the Supreme Court, where every member believes in the rule of law. They may have different visions than you or I about what that entails, but I do think that I love Evan's analogy of getting your wallet stolen because I think it's very provocative, and I'm not sure I agree with your take on that. I think if somebody snatches my wallet, I am 100% not going after them because I am afraid of what else they're going to do to me. I'm going to let them take the wallet and run off with it, and I might call the police, or I might not, depending on my view of the legitimacy of police in our society and what they're up to these days. But I think that the increasing escalation. When I was a wee law clerk on the Senate Judiciary Committee, the idea of going nuclear on the filibuster was the unthinkable thing that surely we would never arrive at. It was only a few years before that the idea of filibustering the candidacy of Judge Estrada was the unthinkable thing that Democrats had done. And every unthinkable thing falls by the wayside within a few years. So I do think that the increasing escalation is a real concern, but I still support packing the court despite all that. And in fact, I wonder, this is a question because I'm not an expert in this area. I'm just a concerned fan. I wonder, as a professor who gets to think not what's the good political solution, but just what would even be a good structure if we could have one. I'm not sure why a Supreme Court with a countable number of justices is better than a Supreme Court with an uncountable number of justices. Whether that's we just decide to go up to 45 justices, and that's our Supreme Court, where not only can no American sort of ordinary person on the street keep track of who's on the Supreme Court. We're already there. A majority of Americans can't name a single Supreme Court justice, but even the professionals don't know who's on the Supreme Court. We don't collect their biographies like baseball cards. We don't pay attention to Supreme Court hearings because there's just so many of them. They're always going on. I'm not sure why that's not a better world than the one we live in. I think if you go from 9 to 13, will we go from 13 to 17 at some point? Probably. We'll try. I love to think that Mitch McConnell's out of ammo, but I'm not sure Mitch McConnell's ever out of ammo. I think he's always capable of imagining the next thing. But I do think that the salient point is lifetime appointments are the rule under the Constitution, and statutory change is the only option. I'm once again grateful I'm not the one who has to figure out how to break us out of this death spiral. Although if I do, I'll be sure and let everybody know.
So we've had several views that the Constitution, one problem with the Constitution is it's just too hard to amend. So what any ideas of what the amendment process should be? What would be a better amendment process? I mean, I take it we would, you wouldn't want to have it as easy to change as a law. And you wouldn't want it to put it to just a 50% popular vote, but a supermajority of the popular vote, a reduced majority of the states, not 3/4. What should it be? What's the right way to think about the structure for changing the Constitution? New York has a yet different method, which is the legislature has to pass verbatim a constitutional amendment twice, and then it goes to a popular vote, but a simple majority. I mean, what should we do for the federal government?
I have a thought on it, again, informed by the comparative stuff. And it's actually really in the context of the democratic backsliding we've been seeing around the world. We do see a number of countries where a majority will get just a sufficient constitutional majority to amend the Constitution and then grab all power immediately on the basis of a single, aberrational election. That's what has led to the end of democracy in Hungary and arguably Turkey and Venezuela, et cetera. So I do think there is some room for just the kind of institution you described, where an amendment would require 2 successive votes of the legislature and, with an election in between. Because that way, most amendments, if they're just technical or small, they're be passed uncontroversially. But if it's really an important thing, if it's a naked power grab, it allows the opposition a chance to mobilize against it. And I think that would be a healthy thing. We're in a long extended period where the formal mechanisms of Article 5 are just not really feasible. And that's probably going to continue. And again, that's distorting because it leads to people to turn to the courts for constitutional amendments. So I'd like to see a lower threshold, maybe just 2/3 of both houses or something like that. But the intervening election, I think, is an excellent idea.
Yeah, I haven't thought deeply about how. I think it needs to be easier, but not too easy. But I really like what both of you have just said. I think some version of the 2 successive votes in Congress with an election in between, followed by a ratification that, in my view, off the top of my head, ought to be a ratification by the people, not by the states. I think that's the crucial thing that our Constitution, that we really need to fix in a number of arenas where we've overstructured around states and not thought about empowering the people more directly, but still with checks and thresholds and so on. So I would lean towards something along those lines as well.
Let me ask you more. Why should we have states at all?
Oh, wait, before we do that, can I do the
Sure.
constitutional amendment one?
Yeah.
Because I just love this. Yeah, I think New York system is good, but I would propose one change, and I'd love to know from Professor Ginsburg if there are any other examples of this in other countries. It seems to me that the New York's process is great, but I would want to take some of the constitutional protections we have and put them into a higher degree of protection against amendment. The current Constitution's amendment process is already almost preclusive, but we've chosen to single out, for special difficulty of amendment, one of the worst parts of our Constitution. Article 5 says, no state without its consent shall be deprived of its equal suffrage in the Senate. which is terrible. It's it's not the worst part of the Constitution. There's a great book where they asked con law scholars to pick that, and they said you can't choose the 3/5 compromise, which was obviously the worst part of the Constitution. You also can't choose the Electoral College because everybody would write about that. So somebody came up with the fact that the vice president presides over his own impeachment trial in the Senate. That's almost certainly the founders just had a little brain fart there, but in terms of the no state being deprived of its equal suffrage, couldn't we do that, but for better parts of the Constitution, like the parts that guarantee us equal rights and due process, and say, we can amend all the other stuff. We can, as a trans person, I'm not super eager to have my rights voted on right now. I think maybe 10 years from now, that'll be great. But I'd love to continue to enjoy the benefits of those amendments without the possibility of popular amendment, while still you can add whatever you want. You just can't touch those.
Well, that's an easy way to think about the Constitution, right? Is it's got things that guarantee rights, or at least protect from governmental intrusion on rights, and it's got other things that set up the structure of the government. Admittedly, there are some places where it's not quite clear which is which, but by and large, you could separate it that way. What about that sort of a system where it's much harder to amend the Constitution to alter the rights related pieces, but the structure, how you apportion Congress, or who votes for what, who presides over what trial, the structure of the government more freely amendable. Make sense?
Well, I don't want to protect all the rights. I don't want to protect the Second Amendment, frankly, and I don't care about the Third Amendment, because quartering soldiers in my home just isn't something I'm worried about. I just want to take basically the Reconstruction amendments. Maybe I can think about some other ones in there, but that's my world.
I guess we have to make you czar or something like that, though, to think of a principled way to
just have a little constitutional convention in my house. I think
could do that. So back to Congress. How could the Constitution be restructured to better empower Congress? What has failed?
Well, one thing, most of our practices of congressional oversight are not constitutional, not enshrined in the Constitution. And so guaranteeing oversight power, we had several examples where the Trump administration, would have officials not answer subpoenas and things like that. You could really beef up the actual tools Congress has, and not just leave it to the political process, which is what the Supreme Court does. So that I'd like to see a textually guaranteed right of oversight. I actually have something else that I think is important, which a lot of other countries have and we don't, which is to designate in Congress a leader of the opposition. Many systems have that. In fact, many systems have opposition parties with rights to chair certain committees in Congress, even when they're out of power. And that can be really good in terms of sort of depolarizing, because even if you won this election, the other guy's going to be watching you, and one day you're going to be in that other guy's seat. And I think tends to lead to systems where we don't demonize each other so much. The problem of Congress today is one of polarization at the bottom. And it's ultimately, in my view, caused by the fact that the Constitution allows state legislatures, partisan bodies, to draw the lines for the districts. That's certainly, Ava, one of the candidates for stupidest provision in the Constitution. And it's causing no end of mischief. That has led to a polarized Congress. And that, of course, has meant we've had a dysfunctional one.
I pick up on that last point. I think one of the biggest contributors to the dysfunction of Congress now is gerrymandering and the bad districting, which makes many members of Congress almost impervious to defeat, at least from the general electorate. They only have to worry about the fringe and the extremes within their own base that is disproportionately empowered by improper manipulation of the districts, where as everybody's now saying, the lawmakers choose their electorates as opposed to the other way around. And I think that has contributed to the sorting and the polarization in our politics. And the other major problem that needs to be addressed structurally is money in politics, the way in which the elections become chases for money and dictated by money and so on, not entirely, but way out of whack, to use Biden's phrase again. So I think addressing those two issues are two things that could help re-empower Congress to be more functional.
So I wonder how much
I also think, it is okay to have division and conflict, as several people have said. It's a messy, complicated country with lots of different views and lots of different opinions, and we need a means of working those through. And sometimes the majority is going to prevail, as it should, and some of us are not going to be happy for a period of time. As long as there, however, is a pathway for persuasion and change and engagement, and certain boundaries and protections, as Professor Ayers talked about, then if the system is functioning to represent people and to engage people and not represent a billionaire class or a political center or a fringe in a way that's unaccountable, then we can make democracy work. That is the messiness of democracy.
I mean, there is a little bit of a chicken and egg problem in my next sort of question, but how much of the polarization in whether it's the Congress or the Supreme Court, or even in state legislatures, is a result of polarization of society, or does it work in the other direction? Because there's and how much of that is that it's just now because of when I grew up, there were basically 3 national news broadcasts. If you picked up a newspaper, it kind of had the same information as every other newspaper. Occasionally, if you had a public television station that had its own news program, as we did in the Bay Area, you'd get something you might call a different look at the news. But now there's, a million different sources. My kids, one of whom is an adult and the other is nearing adulthood, rely on all kinds of things for sources of information, many of which are, there's no truth behind them at all. Has sort of technology overrun our ability as a society to have that kind of a civilized discourse about issues? Because when people believe things that are just patently not true, it's very hard to have a civilized discussion. Is that a problem, or I'm just over worrying?
Well, okay, let me try. I guess I want to challenge the premise that polarization and factual misunderstandings are the main problem here. I certainly think they are problems, but I think that the word polarization carries a lot within it, and it's important to separate out some of those constituent elements. When I think about polarization, I think about motivation. What is the driving factor for our political parties? And ideally, you would hope that a political party would be driven by trying to identify constituents and possible voters and do things that A, they'll like, and B, will benefit them, understanding that those two things are not always the same, but that some mixture of those two things are going to be the driving motivator for political elected officials. And so there's a book I like that I recommend to folks called Asymmetric Politics by political scientists Matt Grossman and David Hopkins, talking about how what we're seeing is not a universal phenomenon of polarization, but a significant break in the Republican Party's behavior according to that model. That when you talk about ideology as a motivator, and you mean being detached from the interests of your constituents and being focused on something else, that's a behavior that you see significantly more in one party than in the other. And that's a difficult thing to say because it sort of violates some norms of professional discourse and objectivity that political analysts are often thought to be supposed to follow. But I think, for me, the idea that politicians are responsive to their constituents is the grounding norm that we ought to be concerned with. And, I'm not sure people are more prone to misinformation now. We for the first better part of this country's history, vicious racist misinformation was universally held to be true. And nothing about our democracy prevented the idea that people of color were inferior from being a universally predominant assumption. We've never been that great at getting the facts right as a country. Our democracy has survived a lot of corruption and a lot of misinformation. What worries me that it can't survive is, the fact that a politician who stops voting according to a rational conception of what their constituents want or need is no longer a politician who's subject to the rules of democracy that our whole system depends on flourishing.
Well, that in some ways goes back to the campaign financing point, right? So I noticed in one of the, I've been trying to keep my eye on the chat a little bit. One of the comments, and I'm going to change it a little bit, but really had to do with sort of whether it wasn't phrased in terms of the failure of the educational system, but whether there are things that the educational system could do to sort of better equip Congress, but I assume it would be really anybody in public service. I think partly to motivate people there, but also to sort of tie them back to the idea of not just attachment to the country, but really working in the benefit of the country. That is, isn't some of what we're seeing in Congress in terms of its dysfunction a failure of the educational system? I don't know if anybody has views about that.
Well,
and then what can we do?
Yeah, I mean, yes, we are definitely paying the price for a very poor public educational system. Numbers compared with other advanced industrial countries speak for themselves. But the specific point about, Congress, first of all, I think in response to your earlier point about the digital era we're now in and the sources of information, I would like to see a more general program on digital citizenship around the country. It's a new era, and you can't, just because it's on the internet doesn't mean it's true, obviously. So how do people go about figuring that out? Now, I have obviously not been in high school for a while, and my kids are older than that, but I don't think we have a sort of generalized program on that. I'd also like to see something on government ethics, basic ethics. There's just nothing on ethics that anyone gets taught. And we are obviously having a lot of contestation over the treatment of American history and things like this, and state mandates and such. I really think most of that stuff should be a local issue, honestly. I think we need to keep the things which we have to come together on are not a single uniform shared vision of America, but mechanisms for communicating with each other so that we can work it out when we're adults. That's what I'd like to see.
I think I'd like to tie the question about education kind of back to our earlier discussion of rights in the Constitution. And I think, I really like the idea that Professor Ayers mentioned about, entrenching certain rights provisions in unique ways in the document more so than maybe other provisions. But I just wanted to point out, as we've been talking, and gun rights have come up, and this, I've been thinking about some of Robin West's work on, I think, what she calls tragic rights, and I just want to observe that the rights that we recognize in our Constitution are already, they're not positive rights, right? So when you think about education, right, there's no right to education, there's no right to literacy. Though I want to say the Sixth Circuit came close, but then that went away. But maybe it wasn't the Sixth. Anyway, right. So they're not positive rights. And her work is a little bit, several years ago, but I think it's applicable. They're not even really negative rights. They're things that she talks about as exit rights. So the idea that, the state won't adequately educate its populace, and therefore, people have, the right to homeschool is not a federal constitution, like, therefore people do it themselves. The state won't, the police are ineffective and in many ways harmful, and therefore people demand gun rights, right? Like the state won't, provide services for pregnancy or childbirth or maternity or childcare. And so people demand the right to abortion, right? These are rights to like opt out because the state is so shattered and there is not. And so what she proposes, she goes back kind of to bring it full circle to what we started out by talking about as it's about people engaging and building community, because the rights that we are recognizing are really, and I don't know if, I assume maybe Professor Ginsburg or someone who thinks about other constitutions might have other things to say about this, but are pretty limited and minimal and are real. And I mean, she has many more examples of that in the work, but I think I'm not sure. I would just want to make sure that we understand that when we talk about educating people, part of the structural failures of government have relegated us to this set of rights that's relatively minimal. So,
can I come back in on this point? It's true that if you compare our Constitution with those of many around the world, we don't have very many rights. But it is also the case that if you look at state constitutions, we do have a lot of the rights that are found in other countries' constitutions, rights to education and such. And so, the question is, how do we go about figuring this out? And this, in a way, brings us back to the very beginning where we're talking about, well, should the Constitution be something that just 9 people decide, or is it something that we're living with and developing ourselves? A point I'd like to make there is about gun rights, because I just think we have to put this on the table. It's a kind of tension in our conversation. Gun rights have changed radically since the founding. Back then, you could, many laws did stop lunatics and other folks from having guns, and you couldn't bring a gun in a church and things like this. We have expanded that right, and we have done so because of a social movement. And you might not like it, but that's exactly the kind of dynamic which we were sort of talking about was a good thing. And so, I think if we're going to leave it to we the people, which I think we have to do, you might get some outcomes that we don't all like, but at least it will be responding to felt needs in that particular society. And it might be Jessica, calling everyone, Professor Naus and Robin West could convince people that, don't worry, the state will take care of you. But that really kind of cuts against the grain of our political culture, unfortunately.
Yeah, sorry.
No, please go ahead.
I'm largely in agreement with that. I mean, personally, I would favor a right to healthcare, a right to education, and we could probably, many of us here would have a long list of substantive rights. But I actually think if our system functions properly, when we make it function properly, we can deliver on those things. And your example, is a little unfair, but you criticize the freedom to marry movement, you laud the gun movement, and I know substantively that's not really what you're saying at all. But you are largely correct in that both of those movements, those efforts, represented people who had a vision of what our country ought to be, who engaged the system in all its many parts, and were able to deliver the country and the system and the result that those of us who wanted it wanted, and make it constitutional in that sense through the Supreme Court at the end of that very long process, which of course doesn't need to be the end, because those of us who have a different view of guns could also engage that system and get justices to properly interpret the Second Amendment and to do the right thing instead of packing the court with those who are not going to do that. There's a book called Engines of Liberty by David Cole that makes exactly this argument, using exactly these examples and others, talking about how the Supreme Court is not who makes the law. It is we, the people, including through the Supreme Court in the various processes. And I do believe, imperfectly, we could get healthcare in this country much closer to what I want it to be. We could fix our educational system much more to what I would want it to be, not by having to wave a magic wand and lock it into the Constitution, but by properly engaging the political process, and indeed perhaps pushing back on a Supreme Court or other political forces that have been temporarily stacked against some of those efforts, as we've seen in those kinds of efforts in the 60s, the 70s, the 80s, et cetera. So that's another example of where I don't think it's though our Constitution is deficient in some of the substantive guarantees that other constitutions, including state constitutions, do have, I don't think that's the big problem. I think the big problem is the structural elements of our political system have not kept pace with what the people want and are indeed skewed at limiting the people's ability to achieve these things. And that's what we need to fix.
So my impression is that the courts have been fairly reluctant, might even be putting it a little mildly, to look at foreign law, to look at things like the Uniform Declaration of Human Rights or other international, some cases treaties, some cases pronouncements, declarations, those sorts of things, to say, oh, gee, maybe we ought to incorporate some of that into the law of the United States. So taking the point that we, the people, need to bear some responsibility in this, how realistic is it to think that things that become accepted more globally that we lack, that the people are a way to try and move us towards what other nations, what the world sort of thinks as is civilized or essential rights?
Can I say something on that? I think that it's a fascinating fact that the social movements that we've been talking about, and just to be clear, even though I would probably pick different rights to enshrine, I'm a huge fan of living in a society where social movements determine or have a role in figuring out what's going to make it into our legal system as a protected right. So, whether I would have a Second Amendment or not, I'm grateful to live in a society where that's not entirely up to me or any other single person. But I think that the way that social movements shape legal discourse, which is 100% true, is a chicken and egg thing, like you, in your words, Judge, where it's curious that when we talk about rights in the United States, I think, and I'm not a sociologist, but I think people are vastly more likely to mean our Constitution than international law, even though international law is a rich source of rights that in many countries are treated as something to which a response is required, right? Something that needs to be addressed. When Human Rights Watch releases a report, it's sort of a weird fact that even though Human Rights Watch is just a bunch of folks who have no standing in any governmental system, governments all over the world feel compelled to issue responses that say, we are not violating the rights of our people as recognized in international law, because that has rhetorical force, it has force in the discourse. My sense, and I'd certainly defer to others on this, is that we as a country have put a lot more of our rights discourse into the Constitution than into international law. And Robin West talks to some extent about how we put a lot of our moral discourse into the Constitution too, to the point where sometimes we can't tell the difference as a society. I think her example is talking about the First Amendment, where we get very confused and think that, I remember once seeing an interview with Eminem, where he was being criticized for some of his lyrics, and his response was like, I'm exercising my First Amendment rights, as if that was a moral defense to saying terrible, horrible things, right? We sort of, the person who exercises their First Amendment rights has a sort of heroic tinge about them in our culture for reasons that I think Robin West talks about as bound up with the way we think of rights as a moral quality and not just a legal liability or responsibility that others have. And I do think it might be good if we could put a little bit more of that into international rights, if only to sort of flex our muscles and stretch a little bit and learn to think a bit more creatively. Same thing for state constitutional rights. Most people don't realize in New York State, you have a right to a basic level of welfare, that the state can't let you starve here, that's a right that you have. I was a bit shocked when I found that out, even after law school. The breadth and diversity of the things that can be considered rights, I think, would be much richer if we were a bit more open in our discourse than we are.
I'm so sorry. I think I had technical difficulties before. Can you hear me now?
Perfectly, yes.
Okay, wonderful. Thank you. I apologize and it may happen again, so I'm sorry. I love the idea of, looking internationally. I just wanted to kind of reiterate something I alluded to earlier. That was, I think that to the extent we want more robust rights and more robust examples of what our rights could look like, we don't need to look that far. And I talked a little bit about the amendments earlier, and we've talked about several of the amendments. I just think we have, in our history, we have repeated examples of ratifying amendments and then courts giving us less than we thought we were getting. And so I just want to underscore that there's work to be done internally in the Constitution. And I think I'm thinking from this, one good example comes from, Reva Siegel's work and others on the 19th Amendment. And the idea that it was not, it was not anticipated to just be, I mean, today we think of it as like the right to vote, right? It's all about voting, but it was the pre-ratification debate and the concerns that people that opposed it had were about, it was going to transform women's status within the family, within society. It was going, and there are, a couple of early decisions where it was read differently, and then that all goes away. And I think, and that's not the only example of that happening. So I just want to, remind everyone that we can work from within our document too, to get more robust iterations of rights.
I mean, my prediction is that most of the developed nations in the world will consider the death penalty unlawful before the United States gets there. What do we take anything from that? Can we do it? Does it give us any currency to point out what other countries have come to, if that's where they come to?
Yeah, I mean, the debate you were referring to before was largely actually really a debate between two individuals, Anthony Kennedy, who keeps coming up today, and Justice Scalia, who every time Kennedy would cite, the European Court of Human Rights, Scalia's head would explode, basically. Yeah. And, to me, it's obvious that we have a lot to learn from other countries, right? Not just in terms of constitutional design, but in terms of what these rights mean, how other people, other humans have wielded and shaped the meaning of these fairly abstract principles. So I think we certainly can learn. Although, on the other hand, and this was one of Scalia's critiques, the problem is who you are picking as your comparators. And that's almost a social science question, actually. Social scientists have to do this all the time when we do comparative politics or comparative analysis. For courts, judges aren't particularly skilled in that process or the method there. And so, it depends who you pick. On the death penalty, it is true that Western Europe and Latin America all abolished. But you have other advanced industrial societies like Japan, which still have it, and obviously many other large countries like China and the Philippines and such. And so it's hard to figure it out, because you need a theory for exactly what the information from the other countries is telling you. Now, in my view, we have a lot to learn. No one would say that those countries' rulings or international human rights laws directly applicable, but we still have the capacity to learn as a people from those things.
We were planning to leave about 20 minutes or so for questions, and we're sort of nearing that point. Let me wrap up with a proposition, though, and see, which requires me to read a little bit, and see if we get any reactions to that, and then we'll move on to questions, unless anybody else would like to sort of wrap up. But as a proposition, let me start with that the principal failing of the Constitution was its definition of who counts as Americans as less than the people who should count as Americans. And I mean, slavery was certainly at the forefront, but that's it's of a piece with the exclusion of all sorts of other people. And so let me read you a hopefully not too long quote from Tocqueville's Democracy in America, and see if we get a reaction on the broader point, not simply on race. The most formidable of all the evils that threaten the future of the United States arises from the presence of blacks on their soil. This evil is slavery. After abolishing slavery, modern people still have to destroy three prejudices more elusive and more tenacious than slavery: the prejudice of the master, the prejudice of race, and finally the prejudice of the white. In nearly all the states where slavery is abolished, the Negro has been given electoral rights, but if he presents himself to vote, he risks his life. Oppressed, he can make a complaint, but he finds only whites among his judges. The law opens the juror's seat to him, but prejudice pushes him away from it. His son is excluded from the school where the descendant of the European goes on to be instructed. In the theaters, he cannot, even at the price of gold, buy the right to sit next to the one who is his master. In the hospitals, he lies apart. The Black is allowed to beseech the name of the same God as whites, but not to pray to him at the same altar. He has his priests and his churches. The gates of heaven are not closed to him, but inequality scarcely stops at the edge of the other world. When the Negro is no more, his bones are thrown aside, and the difference in conditions is found again, even in the equality of death. Thus, the Negro is free, but he's not able to share either the rights or the pleasures, the labors, the pains, or even the tomb of the one whose equal he has been declared to be. He cannot meet him anywhere, either in life or in death. So, how well has our society, with the Constitution that we have and the interpretations we have, work to erase not just prejudice, not just racial prejudice, but prejudices of all sorts? And isn't the fundamental problem that we have, even when we talk about polarization and different views and inability to have civilized discourse, doesn't it root itself ultimately in prejudice against the other? And we see this maybe even in immigration, in a variety of things that are sort of hot button topics now, that at the root is the inability of our society, as much as we like to think of ourselves as a melting pot, to erase all sorts of prejudices. I don't know who would like to tackle that. Professor Ayers?
Okay. So, well, let me say this. I think one of the challenges here is that as society moves through time, we need to be able to take account of forms of knowledge that we haven't taken account of in the past. Understanding the other, as you're discussing, is often a matter of trying to understand somebody whose experience is fundamentally different from you. And we've failed over and over and over again to do an adequate job of that. And I think that as we think about new structures, there's no question more important than thinking about which structures will allow us to do the best possible job of getting beyond the biases and prejudices that are built into to all of us, and that will enable us to take account of other people's experience in a way that we haven't. Let me just to give an example. As a trans person, I have a piece of knowledge that cisgender people, for anybody who doesn't know, that's a word that means people who aren't transgender, you all don't have, which is that I know what it's like to be transgender and you don't. And there's an experience of gender dysphoria, which many but not all trans people experience, that most cisgender people never do. And the Constitution, in the sense of the body of precedents, not the discourse and not the text itself, but our law, often works by balancing interests. Apparently, this is especially true since the 1950s. I'm not a historian, much less a constitutional historian, but I gather this is sort of an eruption that's happened in modern constitutional law, right? We like to balance interests. It makes people very nervous sometimes because it feels like naked policymaking, just weigh the government's interest against the individual. But what goes onto those scales is often the experience and interests of one person or one group versus the experiences and interest of the government or the people. And to be able to do that analysis properly, knowledge like, what is gender dysphoria? How bad is it? Judges have to put themselves in the shoes of other people all the time. Judge Lynch, who I clerked for, used to say that he loved being a judge because it let him get all up in people's business. You spend one day on a trial about the New York City jewel industry, another dealing with high profile corporate problems, and another dealing with some prominent hip hop artists. And you move through life learning to encounter different people. That as a judge, that's part of the joy. But it's also, despite, I love To Kill a Mockingbird, and I wrote an article about it. What a lot of people don't realize is that Atticus says that famous line about walking a mile in another person's shoes. He then dramatically fails to do that throughout the whole book, to the point where he thinks the neighborhood psychopath can be trusted and allowed to walk free, upon which the neighborhood psychopath promptly tries to kill his children. Right? Atticus is not great at walking around in other people's shoes because it's so hard to do. So I think as we think about all these structural problems, it's really important to think about how do we select people, not because they're the youngest partisan ideologues we can find, which as was said, is the current primary test for Supreme Court justice candidates, but how do we find people for the courts who will be able to take on that incredible responsibility? And I think curiosity is the prevailing trait among the many other things that you need to be a successful judge. Our reform processes, I think, haven't really grappled adequately with that need.
Anyone else?
I would just say I love everything that you just said, and I think in all of those things, and it's so important, the idea of understanding that, you know, what a group of people can be in the same room or in the same circumstance and all experience it entirely differently. And you don't know what those experiences are until you ask people what those experiences are and find out how it's impacting them. And I think that in terms of the Constitution, you know, we in our history, like people who are in positions of decisional power regarding the Constitution need to be cognizant of you know, that we live in like the wake of slavery and all of the ripples of the, you know, these institutions and patriarchy and all of these things that were foundational to the document and foundational to our history. And that in so many ways, you know, there's still, you know, I come across just recently, you know, like new work that makes me think like, wow, so to take a constitutional example, you know, the 13th Amendment, right, abolishes slavery, but it's not, and supersedes the Fugitive Slave Clause, but it's not just that. There's this new, I think, what's his name? Justin Simard, I think, anyway, was writing an article about how judges all the time still cite cases that involve enslaved people, right? And that's a piece of like us not acknowledging the import of the 13th Amendment, and that we've moved on from that and not acknowledging who those people were and what was going on, you know, that for propositions unrelated to slavery. Sorry, I should say that, that there are these cases that involve you know, disputes over the ownership of slaves or whatever, but they still come out for other propositions, maybe in contravention of the 13th Amendment, and that there's so much that is baked in that if you're not constantly questioning and constantly attentive to, you would miss. And so I just think it's really critical of the things that Professor Ayers said to think about decision makers having that ability to, I think it's really empathy, right? And the desire to understand what another person's perspective is. So
I think I would just add to both of those comments that while we are in a moment where we are talking a lot about these different kinds of exclusions and the history of structural racism and of the denial of trans people and gay people and minorities of all kinds and of women and so on, and rightly and necessarily so. And those are absolutely enduring fault lines in our society, and that there are places where America has stumbled again and again in its history, as have other countries. And therefore we must call ourselves to them. That's all true. It is also true that there are other threats or concerns or just issues that need to be attended to, such as the abuse of power by those who seek power, the abuse of power by those who seek wealth, the creating a society where people can disagree even over big things and still coexist. And while it doesn't take away anything from the importance of that first basket of things we ought to care about and work on, to remember that the Constitution is also intended to be protective and addressing those more universal, sort of less identity by identity, category by category, person by person, subjective by subjective basket of things. And we need to pay attention to both, while allowing for some flexibility and disagreement over some of these things, because ultimately human beings do disagree with each other. And the real challenge is, how do we create a space where everybody can have a more perfect union and the pursuit of happiness with basic freedom and momentum for equality?
I'll just add one thing, although everything everyone has already said has been so eloquent. Yes, to follow on to Paul, I think the important thing is to channel our disagreements into problems that can be solved through politics. And that has to do with the control of politicians, as well as how we get the goods, which will allow everyone to thrive. I would just like to add, though, going back to Tocqueville, the most sophisticated, most intelligent observer of the United States ever, and he was an outsider, that the specific role of anti-Black racism, which is really something that is distinctly American in its intensity and has distorted our politics rather uniquely. And that may be something where we need some transitional justice kind of mechanisms, like many other countries have dealt with, to move us past that. I would personally like to see much more attention to that. I think the rest of it is going to solve itself through struggle.
All right, I think we have some time that we can devote to questions if Meghna has any for us.
Yes, I actually have a bunch of questions that students have posed. So the first question that I have is, what price, if any, do we pay by amending the Constitution otherwise than through the mechanism of Article 5?
I think we've talked about it a lot, right? When judges are making up the Constitution, that makes judges too powerful. So that's a problem. It is worth noting, and we haven't mentioned it, that Article 5 actually has two mechanisms of changing the Constitution. And one is if 2/3 of states call for a new constitutional convention, we could hold a new constitutional convention. This is pretty popular among the political right, and we're not too many states away from that happening. So I think it's worth just putting on the table that we do have a mechanism of doing it again ourselves as we the people. I personally oppose that strongly, because I think we would end up arguing about, affirmative action and abortion and problems that couldn't be solved rather than problems that could be solved. But I think there are big costs to having such a difficult.
I would just say that some people's idea of amending the Constitution is other people's idea of fulfilling the Constitution. And so there are certainly things that are amending the Constitution that aren't just fulfilling. But in my work, for example, I didn't think of myself as amending the Constitution through some backdoor way that wasn't Article 5. I thought of it as fulfilling the promise of America in the Constitution by a proper application of the constitutional values and guarantees.
Anyone else? So the next question I had was more so a general question of, when we're talking about the courts having too much power, are we saying that because of those presiding over it, or in general, the courts are having too much power?
My answer is in general. I'm on the record as criticizing courts in many countries where the judges are deciding things which do accord with my political views, but I just don't think it's the right way to run a democracy.
Anyone else? Nope. Okay. The next question is, wasn't the structure of the Constitution, the division of power at the federal level and vice versa the states, the bedrock protection of our inherent rights per Hamilton based on Montesquieu's critique of government structure? It is interesting that the proposal here was to make the portion of the Constitution more easily amended.
Well, let me offer a little bit of an observation, and then somebody else can pick up. I do not at all believe that the extent of the balance between federal and state power that now exists was anything that was envisioned at the time the Constitution was adopted. And you can see, I mean, even in the 10th Amendment, and that the idea really was that and that's why there's not, for example, the voting was debated extensively at the Constitutional Convention, and no voting right was put into the federal Constitution because the thought was these are really state issues. The federal government was viewed at the time as being something that we needed to have a centralized government for reasons of international relations and from various things having to do with monetary policy and so on. But that by and large, all the sorts of things that we now have a quite large federal presence for were really not things that were envisioned to be federal issues at the time. So the balance, I think, between the federal and state is quite different from what was anticipated then, and that raises questions about whether the structural mechanisms we have for amending the federal Constitution really comprehended the vastness of the federal government.
Yeah, so to add to that, I mean, I think it's a great point that the structural provisions of the Constitution were thought of by the people who wrote the document as significant protections on rights, that division of power and all the other things we study in that structural constitution class that most law students take, that those are significant rights protections. Of course, that was the 14th Amendment and the other Reconstruction amendments had to be passed much later because of significant ways that structure didn't work. In other words, it didn't adequately protect the rights it was meant to. And I think this goes back to something that Professor Naus said earlier in the panel about the relationship between the structural provisions and the rights provisions. And I think that you can see in a lot of contemporary fights over social issues, conversations that are at their base about rights get channeled into conversations about these structural provisions in a way that I'm not sure is great for public discourse. I'm thinking about immigration in particular, where during the Trump administration, you had obviously major differences of view within society about the way non-citizens should be treated. And in the context of sanctuary cities, some scholars have written about the way you suddenly found yourself, if you're an immigration advocate, arguing for local power, which is maybe not something that you care about at all, but that's the way the constitutional structure compels you to frame your arguments, maybe just by virtue of the fact that cities demographically tend to be more progressive and rural areas more conservative. And so you're all for local power because cities seem like the localities that are going to assert that power once you give it to them. But that's not a great way to resolve these issues within our society about whether non-citizens should be treated in one way versus another. So I think that the distorting effect of using structural provisions to resolve questions about rights is a disadvantage. And if I were a genius and a king who wanted to start the Constitution over from scratch, maybe I'd have some brilliant way of addressing that. But right now, I really don't.
Does anyone else have any additional points?
Well, I would just say, as I understand or dimly remember Montesquieu and so on, I think the framers were correct that there were elements of checks and balances and distinction between federal and state and so on that function to also protect rights, to reduce the pernicious effect of faction, as Madison talked about, and so on. I think the problem we have is not that that's wrong, it's that they were addressing the way those played out in a particular set of historical circumstances and geographic population distribution and so on. And we are now in a very different time that has evolved and changed. And so we need to fix the machinery to make sure it reflects the ability to deliver those kinds of proper checks, but also proper vigorous government, commensurate with where we actually live today and how we live today and how we communicate today, to go back to Judge Wilson's point earlier about the silos of information and the ways in which we communicate and so on. So that's what I would add there. And I would just say in response to what you specifically said, Judge Wilson, I actually think, I believe we have evolved through history also to a very different understanding of who we are as Americans and as America in many different ways. And so the idea of a vigorous federal government and the idea of a vigorous national discourse are more important and more authentic to who we are as Americans today, no matter what that would, no matter how they conceived of that 250 years ago. And that's proper also to acknowledge and to make sure that the political mechanisms reflect that existence of the American people and the values of the American people today.
Do we have any other final thoughts? Okay, seeing none, we actually have more questions, but I do want to be really cognizant of everybody's time. We did say the event ended at 6, so I just want to take the time to thank our moderator and panelists for really providing us with a great discussion. It really gave a lot of us a lot to think about, so thank you so much for taking the time. We really appreciate it, and thank you for everybody who attended this event.
Thank you for organizing it.
Yeah, thank you so much.
Yes, thank you.
Okay, good night and take care, everyone.